My name is Sid Mendelson. On my right is Dick Grant, and on his right is Gene Golke, and on his immediate right is Arthur Brown.
Coming in.
Right.
We'll continue with our discussion of Section 12.
And more particularly, Rule 12D1, which, as Sid mentioned on the previous tape, allows investment companies to purchase interests in broker-dealers or IAs in certain limited instances. And essentially what Rule 12D1 does is set up a revenues test, really a revenues and ownership test. And that is, if the revenues from the broker-dealer investment advisor activity of this portfolio company is less than 10%, is 10% or less of its gross consolidated revenues, then for the last 3 years, then the investment company is able to purchase shares in that business, that operating company. However, the investment company and all of its affiliates cannot own more than 10% of the voting securities of that operating business. So that's one test. The revenues, the consolidated revenues of the operating company cannot be derived from broker-dealer or investment advisor activities to an extent of more than 15%, and the investment company and its affiliates cannot own more than 10% of the stock of that operating company. If those conditions are met, then the investment company can purchase shares of that operating company.
This rule came into play in a very serious fraud years ago, not too many years ago, in equity funding. As you know, equity funding was the computer fraud in which equity funding was supposedly selling insurance policies at a great rate, and what it was really happening was that they were putting fictitious policies on the computer, and when the auditors came in, they took the last 3 digits. The computer only had the last 3 digits of the policy. So when the auditors asked to look for a policy with the last 3 digits, they just run around and get a legitimate policy and show it to them, and there was no way in which the auditors could knew whether or not they had had a legitimate policy or a fictitious policy. Well, business was in this paper machine was operating so well that equity funding, who had been operating investment companies, said, and a very prominent Washington counsel gave an opinion that because the insurance business was now more than 85% of the revenues, that mutual funds could now purchase shares of equity funding. And several mutual funds went in just before the bubble burst on the basis of the opinion of a prominent Washington counsel that the 15% rule, the Sears rule, was applicable here. And obviously they weren't selling that as insurance. There wasn't any. It was all fictitious revenue that was in the equity funding situation. But nevertheless, the investment companies relied upon that rule and relied upon the information that was given to them, which was all false, to buy the securities. In one company, a very prominent company, I think it was Dreyfus, the Dreyfus management paid back a considerable amount of the money that they lost in violation, because they had purchased in violation of the rule, even though they had done it quite innocently. Go ahead, Gene.
An alternative test in Rule 12D1 provides that if for the 3 most recent years the revenues from broker-dealer or investment advisory activities of this operating company were less than 1%, 1% in contrast to 15, were less than 1% of its gross revenues, then investment companies can also purchase the operating company's shares, and there is no ownership limitation because the 1% or less is, I guess, de minimis. Now, one problem examiners may have with both of these tests, at least in the current business situation of diversified or conglomerate mergers, is knowing, while you're reviewing the portfolio securities, whether one of these companies, which the investment company has securities in, happens to own a broker-dealer or an investment advisor, has a sub out there someplace. So it might be necessary to, if you suspect it, to ask the investment advisor or do some independent research on the business of certain of the portfolio companies. At least you perhaps can't be satisfied just by looking at the name of the company and say, well, that doesn't sound like a broker-dealer or investment advisor. That type of activity may be lurking someplace in the corporate structure. Now, in addition to the exceptions in the Act and the Rule 12D1, the Commission has also permitted investment companies to acquire another type of interest, or arguably it's another type of interest in a broker-dealer, and that is the repurchase agreement. It might help to explain briefly what a repurchase agreement is and the reasons why they're becoming so popular. Imagine on the one hand a broker-dealer, or let's say primarily a dealer in government securities. Well, in order to effectively operate that business, the dealer has to have a considerable inventory of government securities, and of course the dealer has to finance that inventory, which can be a considerable expense. On the other hand, you have institutions and more other types of operating or corporations that have excess cash available for short or long periods of time. I guess it was just a matter of time before these two sides got together. The broker-dealer would contact the institution and say, or vice versa, we've got 10 million of securities here, can you finance them overnight? Or can you finance them for a week? The institution has the available funds, so they make an oral agreement to enter into what is called the repurchase agreement. And technically what happens is that the broker-dealer will sell X amount of government securities to the institution with an agreement to repurchase those securities at a specified price at a specified date in the future. It could be simply overnight. One side of the transaction today at 4 or 5 o'clock, the other side tomorrow morning at 9 o'clock. Or it could be a month or whatever period of time is agreed upon. The price which the broker-dealer agrees to buy these securities back at provides the going rate of interest to the institution. That going rate of interest is generally higher than the rate on the underlying securities which the institution will hold as collateral, but it's lower than what the broker would otherwise pay for funds to support its inventory of securities. So there's benefits to both sides of that type of transaction. Now,
remember this, that the security here is a government security, and the most important thing I think to remember here is that the credit of the broker dealer is not really at stake, simply because of what the collateral is. It's not. The chances are that the only thing that is at risk here is the credit of the United States. That's a very important feature of this transaction.
And because it's this purchase or sale of securities with the agreement to repurchase, that under the definition in the 40 Act, it becomes a loan, I believe, and therefore an interest in a broker-dealer. I say the Commission considered this in Release 10,666, which referred to before. There's a short discussion there about the repo, and the Commission has decided that it's beneficial for funds to be able to enter into that type of agreement. They can invest excess cash for very short periods of time, and because of the collateral being the U.S. government security, they will allow funds to enter into that type of arrangement. Now, just one note to examiners or to people at headquarters reviewing financial statements of companies that have entered into these repos. Frequently, the investment company would like to show in its portfolio of investments the investment in the underlying U.S. government security. However, in Release 10666, the Commission said that is inappropriate, that instead the investment company would have to show the loan to the broker-dealer with a footnote saying that it's secured by this and this U.S. government security. So when you're reviewing financial statements of funds involved in repos, make sure that they are appropriately showing their investments in these repos. Are there any questions on repos? Frank?
Yeah, Gene, I've heard the term thrown around quite a bit of reverse repurchase agreements. Would this be a senior security question?
The question was, is a reverse repurchase agreement, which is a term that's been used somewhat recently, also a senior security?
The answer is yes. There's a senior security question. It's discussed in the same release, and rather than go into details here, I would suggest that you look at that release. There's at least two, I think there are as at least one paragraph devoted to this type of situation.
Sid, just to add one thing, although I think the release is really the good reference tool, the reverse repo is in some ways can best be understood as the reverse of what Gene has just talked about, the repurchase agreement. Instead of the investment company lending money to a broker-dealer, thereby raising this issue under 12d3, accepting a security of a broker-dealer or investing in a broker-dealer security, the reverse repurchase involves a borrowing by the investment company from the broker-dealer. So the investment company is issuing a security to the broker-dealer in exchange for money which it's borrowing. The terms are somewhat confusing in that government securities normally are collateralizing the security in both cases. But it is helpful, I believe, if you look at the repo as a lending by the investment company and the reverse repo as a borrowing by the investment company.
And that's why it's a senior security.
Right.
There's a senior security question because it is the issuance of a, quote, debt security.
I've just mentioned this in passing, that the staff has received several applications, none of which have yet gone to the Commission, in which people are wanting to organize a short-term municipal bond fund as an alternative to the typical money market fund, and in order to stabilize the net asset value at the desired $1 level, they are proposing to get standby commitments from broker-dealers to repurchase from the funds at a specified price these short-term municipal bonds in the fund's portfolio. The applicants, at least arguably, say this is not an interest in a broker-dealer. I'm not sure we have decided either way yet. I say this Commission hasn't issued the order or hasn't noticed in these applications, but it's possible that they will, and that this might be another type of interest in a broker-dealer which investment companies will be getting into in the future. I think finally we have Section 12F. I believe that too isn't used very frequently. I think it simply says that one registered face amount certificate company may organize and acquire stock of not more than 2 other face amount certificate companies. And that if it does so, the stock so acquired must be held for investment, and that the total cost of this stock cannot be in excess of $1.5 million. If these other face amount certificate companies happen to be foreign, the total investment cannot be more than $500,000. And even though the stock should be purchased for investment, it can be sold if in fact it was purchased in good faith, or with the good faith intention of holding it for investment. So it's probably not a very much used subsection of the Act.
Okay, the only remaining subsection of Section 12 is Section 12E, which provides that notwithstanding all the other restrictions on investments by investment companies may invest in venture capital companies. Of course, Section 12E has its own restrictions. The first restriction is that the venture capital company issue only one class of common stock and that it borrow only from a bank. The second restriction is that the investment company not invest more than 5% of its assets in the venture capital company. The third restriction is that the venture capital company not have more than $100 million of paid-in capital. The reason this section is in here is that the problem of raising capital for small business, new industry, the venture capital business, is one that has a special place in the economy. It's a difficult thing for small businesses to get seed capital. Investment companies are a good source of that kind of capital. But and small businesses are viewed as a vital aspect of the American economy. And so this section is just designed not to place what would be viewed as unnecessary obstacles in the way of capital formation for small venture capital companies. And that wraps up Section 12.
Any
Is
questions?
there any questions?
I have one question back on 12D3, which I know is a very troublesome area. That's the one that prohibits investment companies from owning interests in principal underwriters, broker-dealers, and investment advisors. I just have a hypothetical. Actually, it's a hypothetical that's an application currently before the staff of a closed-end company with internalized management. And there's been a lot of pressure in those companies, and we've seen recently the switching over from internalized to externalized management in that situation, partially because of the incentive that it would provide for the employees, the internal advisors of the closed-end company, if they had they were set up in an external corporation whereby they could attract new business and perhaps increase their compensation. In the pending application, the closed-end company wants to incorporate their internally held advisor, which is now just consists of employees, and they want to incorporate that advisor and wholly own it. It would still continue to render advice to the investment company, and in particular circumstances would take on new clients. Now they've run afoul of 12D3 because if they incorporate, even though they have a wholly owned interest in the investment advisor, they violate 12D3, and none of the exceptions which Gene and Dick talked about apply. I don't really think there's a right time to resolve those issues, but I think that we may see some cases where exemptive relief may be quite attractive. I only mention that because before we did talk about all the problems that are created by ownership of broker-dealers and advisors, but there may be situations, particularly with the changes in internalized closed-end companies that we're seeing, which will let us open up 12D3 a little.
Well, of course, there's a precedent in the Broad Street Group that owned an investment advisor. There were how many companies in the Broad Street Group? Quite a few.
4 or 5.
And they together owned their investment advisor, which provided investment advice, and the funds together paid for it.
Yeah, and they really had a specified exemption out of 12.
Yeah.
If there are no other questions, I think I'll move on to Section 18, which has been referred to both in the earlier session because it is inextricably linked with Section 12 and has also been discussed earlier. Section 18 is a complicated section, very much like Section 12, but I think it might best be useful to start not with the particulars of Section 18, but with the purposes behind it. And if you look at Section 1B, you'll see that of the 8 abuses which are listed there, which were findings of the Congress in 1940, almost every one of them has some bearing on Section 18. In other words, Section 18 addresses, in part, almost every one of those 8 abuses. And in the investment trust study, which was prepared by the staff under authority of the Public Utility Holding Company Act, it was conducted up till 1939 and formed the basis for the legislative history. Great abuses were found in the capital structure area, and that's what Section 18 addresses. And I'd say, but for the abuses found which generate from the conflict of interest situation, the greatest number of case studies and abuses related to capital structure. Let me talk about the purposes behind Section 18 and then try to relate them back to the abuses that were found. The first abuse was described as leverage or excessive speculation. And Gene Gulke described this a little earlier. Essentially, leverage is where you magnify your potential for gain or loss on your capital. And it can only really be created in these investment companies by having more than one type of stock. We have a preferred stock and a common stock. The common stock is leveraged because once the preferred stock gets its dividend, all other income goes down to the common stock. On the other hand, the common stock is inferior to the preferred stock, so the preferred stock is assured of getting its dividends or its liquidating value before the common stock would get anything. But it's that leverage on the common stock that was considered a great abuse in 1939, and there are some very good examples, one of which I'll try to get to. The second purpose was the second abuse was overly complex capital structures, and particularly structures that were so complex as to wrest control away from the majority of the shareholders. And that can be done simply by having, again, you need more than one class of stock, but you might have just 2 classes of common stock, one of which has 1,000 votes per share and the other has no votes or 1 vote per share. Now, it wasn't always as simple as that. I mentioned the abuse is complexity. Often there were so many classes of stock that an investor, a public investor, probably just could not ascertain what kind of control he would have over that investment company. So it's a combination. The second abuse I want to talk about is a combination of complexity and control. The third abuse that was found is the inherent conflict between the owners of the various classes. In the earlier example I mentioned preferred and common stock, a very simple case. The preferred stockholder obviously has gone in for the dividend that's been promised. There's possibility that he might get capital gains in that his share would become more valuable, but essentially he's looking for the priority he has and a more secure position. His interest then would be in a portfolio that would guarantee that his dividend would be met. The common shareholder having had the choice of investing in preferred or common stock, is willing to take the greater risk and probably isn't as concerned about dividends. Well, his interest is a little different when you think about what kind of portfolio securities could be part of the company. He might be willing to take a greater chance and would not care to have the bonds, for example, that would protect the preferred shareholders' dividend rights. He might want only equities, because that's what he's really interested in. Well, that conflict exists whenever you have two classes of securities, and was magnified before 1940 because of the great disparity between the interests of the classes. We had very highly leveraged companies. The investment trust study, as I mentioned before, contains innumerable cases of abuses and references to capital structure problems. There's one case that I think covers each of these abuses: leverage, control, and conflicts. And it concerned the United States and Foreign Security Corp., which was a company organized in the early 1920s by Dillon Read. Dillon Read contributed something like 15% of the capital of the company, and picked up special common stock which had special voting arrangements, so that they controlled 75% of the vote by contributing 16% of the capital. That's the control problem. And there were several classes of stock, including another class of common. So you had a complex structure, and they gained control, which really represented a lot more than their capital contribution. Because they had the common stock and they also issued significant amounts of preferred or debentures, but senior securities, they gained leverage. And they gained about 5-to-1 leverage, so that and since they controlled the portfolio, they were the advisor, they were not solely interested in protecting the dividend rights of the preferred stock. And in fact, within a 5-year period, their stock appreciated something like 10,000%. And the preferred people did get their 2 or 3% dividend, or whatever was the market dividend at the time. But it was the chance to appreciate 10,000% really came at the risk of the preferred stockholders. Finally, and really inherent in the same leverage problem, are the conflicts that were between Dillon Read, who had only this common stock, and the public shareholders, who were primarily in bond, debenture, and preferred stock categories. And Dillon Read, as the advisor and in control of the company through their voting, was able to use the conflict to their advantage. The cases, the number of cases that were delineated in the investment trust study were so numerous, so large, that the original proposal was to have a Section 18 of the Investment Company Act which said that every investment company can issue one class of securities only. And all securities in that class have to have equal rights, both as to voting, dividends, liquidation preference, etc. That would have made this entire discussion a lot simpler. But as a result of the compromises that we've heard about in other areas, Section 18 developed along the lines where this one class of security was dominant, but exceptions were carved out so that no one was strictly limited to that one class of security. Before I get into what kinds of securities can be issued by open-end and closed-end companies, I'd like to first discuss a little more what a senior security is. And Section 18G is really where you have to start when you want to interpret the entire section, because it defines senior security. And it defines it as being any bond, debenture, note, or similar obligation or instrument constituting a security and evidencing indebtedness in any stock of a class which has priority over any other stock. There's one general exception to this, and that goes to temporary loans, temporary borrowings, where there's a borrowing that constitutes less than 5% of your net assets and is due within 60 days. That will not be a senior security subject to Section 18. But any other borrowing, any other preferred stock or bond or debenture, or any of the margin or short sales that we've discussed about before, where there's a priority on the claims of the investment company, is considered a senior security. It's a very broad section. It's subject to some interpretation, and I think the staff has been very concerned about the purposes behind Section 18. And I think we've read the definition very broadly, particularly in order to effectuate those purposes, so that margin and short sales, which as Gene went into before, really get to leverage the investment. And that is one of the abuses 1B represents, are defined to be senior securities. And while I say we've read it broadly, I don't think we stretch it beyond its meaning, because as you can see before, those really are borrowings. And the investment company really is subjecting its assets to someone else's priority. It's got to meet the short sale, and it's got to meet its margin call. And it's got to do that before it redeems any securities or pays any dividends. So it's a broad definition, and I think we've used it to encompass more than the things that might immediately come to mind. And that would normally be preferred stocks and bonds. But there are more instruments which do constitute senior securities than those traditional ones.
We have defined options, the writing of options to be a senior security, the writing of a call, where a person has the privilege, the right to purchase a security from you at a particular price. There we have limited such calls to be written by investment companies to be covered, meaning that you cannot, an investment company, an open-end fund, cannot write a call unless he owns the securities, or unless, if he does write the call and doesn't own the securities, then he has to put, as an alternative, he has to put the value of the securities that he sold in a segregated account, either cash or government securities, and he must mark to the market against that security, so that he will always have, so that the investment company will always have the money, either the security or the money to purchase the security, if the call is executed.
Sid, that's right, and that is all laid out in two places now. The options were discussed in the guidelines for the N8B1 preparation. That's an Investment Company Act Release 7221, I believe. Mm-hmm. And the theory behind that is repeated in the release that's already been referred to, 10666, which is a 1979 release. It's interesting to draw a parallel, without going into 10666 completely. There's a very good parallel between what Sid just discussed, the writing of the call option by the investment company, and the issuance of what Gene referred to earlier, standby commitments, where an investment company tells a broker-dealer and gets consideration from the broker-dealer in government securities that he'd be willing to take $1 million Ginnie Mae or other federal, usually U.S. government security, with a particular yield by a certain date. And in order for bearing that risk, and that's the risk of the value of that security going up or down, and where it's a government security, it's going to go up or down primarily because of interest rate changes in the market over that time period. In exchange for giving the dealer in government securities that protection which he needs, he receives a fee. Well, he receives that fee, but he's subject to the right of that dealer to come to him in 30 or 60 days or whatever the time frame is and say, here it is, here's your 9% instrument, give me $1 million. Even though the market that day for $1 million U.S. security might be at yielding 10%. Obviously, the 9% is less attractive, and its market value is really less than the million. Well, that's a prior claim on the assets of the company, which the investment company ought to be prepared to meet, and which can cause great losses to the investment company if it's, well, it can cause great losses in any event, but it can cause great losses in contravention of the purposes of 18 if there isn't some limitation put on that. And the segregated account that applies to option writing, so that you really have a covered option, that same concept has been transferred to the standby commitment situation. You have a segregated account marked to the market, which at least reflects your potential liability. Now, that doesn't stop you from, or stop the investment advisor from managing his portfolio this way, but it does limit the number of standby commitments or options that he can issue. For example, if his net assets are $10 million, he can't go to that dealer and get his fee for a standby commitment, whereby he might have to take $20 million down in 60 days or in 30 days. He's got to segregate the account, and that's the important thing. That's the limitation. He's got to segregate those $10 million. And when he segregates them, it's obvious the most he can take down in standby commitments or by issuing options, if it was a securities area, is $10 million worth. Now, that also puts him in a very, to stretch it to that point, puts him in a very awkward position. If it's an open-end company, he has to be ready to face redemption possibilities. If the market changes, he's got to mark to market those segregated accounts, and he's left himself no room. So, as a practical matter, this segregated account procedure limits the potential liability of any company and their ability to engage in a speculative manner in standby commitments and options. And really, I think the concept applies similarly to the short sales and margin situations mentioned earlier. Well, remembering that we really have a broad definition, and remembering that it's not just bonds, preferred stocks, and debentures that are senior securities, but it's a lot of portfolio instruments and unusual ones, and it's a changing market. So the way investment companies borrow, which is pretty much a way to look at all these instruments, is something that you have to constantly look at. And their borrowings can take many different forms: reverse repurchase agreements, as well as the traditional margin purchase. Remembering that, let's go on and see how Section 18 restricts the capital structure. And I should say that most mutual funds really do have the structure that was contemplated by the original 40 Act proposal. They have a single class of securities. Open-end companies are prohibited from issuing any senior securities, and they all fit into that pattern, with one exception, I think that's been mentioned earlier. That is, they can borrow from a bank so long as there's a 300% asset coverage on such borrowings. Outside of that, there can only be one class of security in an open-end company, and that's provided for in 18F1. Now, as before I get into what asset coverage is, and I know it's been mentioned a lot up till now, I should say that you do have to remember that borrowings, temporary borrowings, which whose amount is less than 5% of the net asset value of the company are defined out of the definition of senior security. They're accepted from that definition. So those sorts of borrowings aren't even considered senior securities. But any other borrowing has to meet that 300% asset coverage requirement. Now, some of you may be thinking of open-end companies, which are essentially series companies. That is, there's an income, it's one company, one registration, but there's an income series and a capital series, or growth series. And there are a good number of those companies, although I don't think there are many now being registered. That would create a problem under this 18F1 prohibition. But 18F2 specifically takes out of the definition of senior securities for this purpose a situation where an open-end company issues two or more classes of security, so long as each security is not preferred, is preferred over every other class of security as to a specific asset pool. So that in those series companies that you may very well be familiar with, the reason we're not having a senior security is that even though it's a one company, what you really do is you have separate pools of money for the income series and a separate pool for the capital series. And therefore there isn't any of that conflict that we talked about out of Section 1B. There's really no complexity. It's just an alternative form of setting up a complex of funds. And there's no leverage. Those are the restrictions on open-end companies, and that is why almost all open-end companies will have no senior securities. The only senior security any can have is the borrowing from a bank where there's a 300% asset coverage. Are there any questions on that? Okay, closed-end companies are similarly restricted, but not as harshly restricted from issuing other classes of securities. Closed-end companies can issue stock, senior stock, where there's 200% asset coverage, and evidences of indebtedness, bonds or debentures, so long as there's 300% asset coverage. But those closed-end companies can only issue one class of each. So the capital structure of a closed-end company is limited to three classes of stock. Three classes of security, common stock, preferred stock, and an indebtedness security. Now, we've interpreted the Act so that you can have various series of those indebtedness. That is, we don't consider it a separate class if you have a bond issued in series, so that there's a series maturing at a different time, so long as the rights of the bondholders of one series are equal to the rights of the other bondholders. We're really following the restrictions of the Act as to abusing the complex system or the complex securities issuances, complex capital structure. As long as those bondholders don't have to read through trust indentures and a lot of other things to find out what their rights are, they know that they're equal to that whole class and that there's only one class. It's not so complex as to be prohibited. Now, that closed-end companies thereby have a great deal more latitude than the open-end companies in issuing more than common stock. And I think in inspections and in review of application and registration statements, you will find that there are preferred stock or bonds issued by these companies.
Art, just one question. Assume you have a closed-end company that has issued debentures, and it also Or is it also possible for that company to borrow money from a bank, let's say?
I think we have taken an interpretive position that privately arranged bank debt is not a separate class for closed-end company. So that closed-end companies have a further out where there's privately arranged debt.
Would that have to come under the asset coverage requirement, or is it exempt from that? You know?
I'm going to leave the details of asset coverage to Eugene, but I think it is considered one of the liabilities of the company, and it would be in the asset coverage test. Let me ask you the question now. I think is a good time to explain exactly what we mean by the asset coverage test. I think up till now we've heard enough about it that everyone's somewhat familiar with the idea that there be this coverage. But I think Gene can give us a definition which is the one to apply.
I think perhaps the best way to look at asset coverage is a concept concerned with the relationship between a company's assets and its senior securities. That is, asset coverage is concerned with determining what number of dollars of assets does the company have standing behind each dollar of its senior security or securities. And this relationship between dollars of assets on the one hand and dollars of senior securities on the other is an important indicator of the risk inherent in a capital structure, not only of an investment company, but of any company. And the greater, I think it's obvious, the greater amount of senior securities that exist for each dollar of assets, the greater is the risk that the company may not be able to pay back debt at maturity or otherwise service its senior securities. For example, assume an investment company has $100 of assets and $90 of senior securities. Well, in that case, the assets just barely exceed the senior securities. If the assets should decline by slightly over 10%, the company may be insolvent or otherwise unable to pay debt service dividends as they come due. Now compare that situation with another investment company also having $100 of assets, but with only $30 of senior securities. In that case, there's more than $3 of assets available for each dollar of senior security. So the assets would have to decline something over 70% before the fund might be in trouble in paying off its or servicing its senior securities. So asset coverage then is a relationship between the assets of a company and its senior securities. Section 18H.
Gene, let me just interrupt you for a second on the question of asset coverage and see if I understand how it works. If you have to have 300% asset coverage, as I understand it, that in effect means you can borrow up to half the value of your assets, in the sense that if you had $1,000 of assets and you borrowed $500, that $500 would be both an asset and a liability. Right. So you would now have $1,500 worth of assets against $500 of liability, and that would be 300% of the liabilities.
Right. Yeah, and I think that'll come out once we go over the provisions of 18H, which state how asset coverage is to be computed. For a evidence of indebtedness in determining whether the coverage is 300% or not, 18H requires that you start with the investment company's total assets and subtract all liabilities that are not senior securities. So, for example, if you have advisory fee payable, salaries payable, rent payable, payables, that type of liability, that would be subtracted from your total assets, since those are not considered to be senior securities. Then you divide that number, that is total assets minus the liabilities, by the amount of the senior debt securities. And that division should come out to a number in excess of 300. If it does not, then the company is not meeting the asset coverage requirements of Section 18. Now, I might say that if a company is proposing to issue a debt security, the computation would be done assuming the security was already issued. And as Dick just said, suppose an investment company has $1,000 of assets and no senior securities, and assume no liabilities. And then it wants to determine what quantity of senior securities can I issue. Well, it would perform this test that I've just indicated as if certain senior securities were already outstanding, and in essence it works down to that you can borrow up to 50% of your assets assuming you have no other liabilities or senior securities, because if you have $1,000 of assets before you issue $500 of a debt security, after the issuance you have $1,500 of assets minus no liabilities divided by $500 of senior securities gives you 3 or 300% asset coverage. And of course there's you might call it a maintenance test, I believe, that once a company has issued senior securities, it has to maintain asset coverage of at least 300%. And if it doesn't, I believe there's certain restrictions that then occur, and which Art will probably talk about.
Right. So, go ahead.
Now, there's a similar computation if the senior security happens to be a preferred stock. Again, you start out with your assets, total assets, subtract all liabilities that are not senior securities, and then divide by in this case, it's not the par value, not the market value of the preferred stock, but the involuntary liquidation value of the preferred stock. That may be equal to the par value, it may be more than the par value. Whatever the involuntary liquidation value is, that's the number you use for determining the asset coverage of the preferred stock. And when you make that division, it should be greater than 2 or 200%.
Gene, if you have outstanding senior securities, which is a debt, you have to also make you push in the computation for that.
Right. And let's suppose then, in a third situation, that the company has both a senior debt security and a senior equity security. Again, the computation is similar. You begin with the assets, subtract all non-senior liabilities, and then you aggregate the senior debt security, the senior equity security, and divide that sum into the numerator, and that result should be more than 2 or 200%. Whereas if you have both a debt and an equity security, you have to have 200% coverage of the combined amount of senior securities. And again, for the preferred stock, if you fall below that 200% coverage, certain things begin to happen to you. Are there any questions on asset coverage? Yes, Kathy?
The asset coverage for debt, if you had both senior debt and senior equity, would be less than if you only had senior debt? In other words, because it's aggregated and you need 200% as opposed to...
No.
Does it like-
No, when you're taking the asset coverage for debt, you only use the debt securities.
Right.
When you're taking the asset coverage for preferred stock, and that's 300% normally. When you're taking the asset coverage for preference stock, then you have to take the preference, the liquidation value of the preference stock, plus the
debt. And
debt as the denominator in your fraction.
I see. But you still compute the debt separately. and
Yes.
it has to meet the 300%.
Yes.
I think you're saying, though, in the case of
Yeah,
senior
both you don't.
stock, the asset coverage is nearly 200%. Does that cause
But in,
the 200% level or the 300% level?
well, 300% if you have debt alone. For debt securities, it must have an average coverage. Now, put that aside for a moment. That's debt. Now, if you issue preference stock, preferred stock, in order to get the 200% asset coverage, you have to not only use the preference stock, but you also have to put in the denominator the amount of debt security, senior securities that you have. These two computations are absolutely different from each other. One has to do with debt alone. When you have that, when you're through with that and you satisfy it, you walk away. The debt securities by themselves are satisfied. When you go over to the preference securities, then in order to get the denominator to the fraction, you must use not only the preference securities, but you must also use the debt securities, and there the measurement is normally 200%.
So you need the 300% for the debt, and if you have both, you still have to have the 300% for the debt, and then for the combined, you have to have the 200%.
Go ahead. Don't
Either. Okay, Mark, go ahead.
Okay. Section 18A, which sets up these two tests, which is, as we've just described, have to be applied separately on asset coverage for senior equity and senior debt, also protects by its provisions the rights and preferences of the holders of the senior equity and debt. And without going into each situation where they're protected, I'd like to point out where there have been arrearages of the dividends owed after a period of time, I think it's 2 years, the holders of the class where the dividends haven't been paid have the right to take control of the company by electing a majority of the board of directors. Similarly, no dividends or liquidating dividends can be issued to any other class of stock unless no dividends unless the asset coverage is still as strong as the 300 or 200% required, and no liquidating preferences unless the preferred stock or preferred debt obviously has had its liquidating dividend paid already. Now, just to wrap up, I might point out the reason that we have these protections here, and that goes back again to the abuses that were found in 1939. The traditional way that the public was taken advantage of through complex capital structure was to be issued the preferred stock and to lose the control over it, with the entrepreneur taking the common stock. And 18A 1 and 2 both go to protecting these preferred stockholders. And the asset coverage itself, the requirements of asset coverage, protect both. It limits the amount that the common stock, the speculative nature of the common stock, and it protects the preferences of the preferred equity or preferred debt. Are there any questions? Okay, I think that wraps up sections 12 and 18.
Thank you very much, Art. Are there any other questions? Any questions at all? If not, we'll prepare for another tape. Thank you.